Thank you for being here. Before we dive in, a quick disclaimer. Most divorce attorneys are hardworking, ethical professionals. What we're looking at today isn't a villain story, it's an incentive story. Divorce is one of the most stressful moments in a person's life. It's emotional, it's complicated, and it's full of information gaps. Those conditions create a marketplace where even well-intentioned systems can drift toward conflict, delay, and unnecessary costs. In this first section, we'll set the stage. We'll talk about why the structure of billing and procedure can quietly reward more activity instead of better outcomes, and how that can show up in your case as endless emails, status updates, and hearings that don't actually move you closer to closure. The point isn't to become cynical, it's to become informed. Here's the good news. Clients who understand the playbook make better decisions faster. You can set clear goals, insist on transparent billing, and choose strategies that prioritize settlement over spectacle. Throughout this deck, I'll highlight specific red flags to watch for, and equally important, practical steps to protect your time, money, and peace of mind. So as we go through, I want you to keep one question in mind. Does this action advance a fair settlement or just create more activity? If you anchor to that, you'll cut through noise, reduce costs, and keep the process focused on what matters: stability for you and, if you have them, your children. With that frame in place, let's look at how the money flows and why incentives can nudge cases toward conflict, and what you can do about it. Slide 2. How the money flows. Let's talk incentives. Most family lawyers bill by the hour. That doesn't reward outcomes, it rewards time. When time is the currency, activities that expand the clock, like long email threads, frequent status letters, and duplicative review, can creep into a case without necessarily moving it toward resolution. Trial preparation is a perfect example. It's thorough, it's important in some cases, and it's expensive. But if settlement is achievable, the incentives quietly tilt toward the more lucrative path, even if it's not the fastest or healthiest for you. You'll also see this in temporary hearings, discovery skirmishes, and motion practice that balloon into mini-trials. Each event can be legitimate. The problem is the pattern. Are we investing time where it produces leverage and clarity, or where it simply accumulates hours? The action step is straightforward. Ask your lawyer to connect each major task to a strategy outcome. What decision will this activity enable? What's the expected value compared to settlement talks? When your team has to articulate the purpose and the price tag, you reduce drift and keep resources focused on closure.
Questionable playbook moves. Now, some tactics that deserve scrutiny. Escalation by correspondence is a classic. Inflammatory letters invite equally heated responses, and suddenly you're paying for a paper fight that changes nothing. Overbroad discovery, like "give us everything since high school," can be leveraged through exhaustion, not information. Then there's motion theater, filing shaky motions to pressure a quick concession or pad fees. You might also encounter gatekeeping with experts, steering to friendly evaluators or appraisers, and churn by associate, where multiple juniors review the same file. Finally, settlement sabotage, last-minute new demands that blow up near agreements only to push you toward more litigation. None of these are automatically wrong. Context matters. The test is proportionality and purpose. Ask, what's the narrowest move that advances our goal? What happens if we don't do this? What's the time budget impact? If the answers are vague, slow down. Tactical restraint is often the most strategic choice. Let's take a careful look at retainers, bills, and red flags, because the document you sign on day one can quietly determine how your entire case unfolds. This isn't about distrusting your lawyer, it's about aligning incentives so your dollars buy progress, not just activity. I'll start with what to watch for. First, non-refundable minimum fee clauses with a fuzzy scope. If a fee is labeled non-refundable, it should be crystal clear what work it covers, when it's considered earned, And what happens if the representation ends early? If that clarity isn't there, you're taking all the risk up front. Ask for an example scenario. If I settle in a month, how much of this is actually earned and what gets refunded from trust? Second, internal communications and administrative tasks billed at lawyer rates. Think scheduling, filing, formatting, scanning, and routine status checks between team members. Those are necessary, but they shouldn't be billed like legal analysis. Either they should be handled by staff at lower rates or built into firm overhead. Ask, what kinds of tasks do you classify as administrative and how are they billed? Third, vague time entries. Phrases like work on file, attention to matter, or review documents with no specifics. If you don't know what was done, you can't assess value. Good billing tells a short story, what the task was, why it was necessary, and what it accomplished, ideally linked to your case strategy. Fourth, aggressive rounding increments. If a 2-minute email is consistently billed at 0.3 hours, that adds up fast. Billing increments should be reasonable. Many firms use 6-minute increments and applied consistently. Ask what increment they use and whether quick tasks are batched to avoid nickel and diming. Now, the better terms you can and should request. Number 1, an evergreen retainer held in trust with monthly itemized statements. Evergreen simply means the trust balance gets replenished as it dips, rather than paying unpredictable lump sums. This protects both sides. Your lawyer knows funds are available and you get transparency and monthly checkpoints. Number 2, a clear staffing plan. Who does what? At which rate and when does a matter escalate to a senior attorney? Routine drafting or discovery tasks can often be handled by a junior lawyer or paralegal at a lower rate, with the partner setting strategy and doing final review. That's how you keep quality high while controlling cost. Number 3, client approval for expenses above a threshold. Experts, transcripts, travel, rush fees, large printing jobs. Pick a number that fits your budget, maybe $300 or $500, and require written approval before those costs are incurred, except in true emergencies. Number 4, no charge for learning curve fixes or firm overhead. You shouldn't be billed for training new team members on your dime, correcting internal errors, or dealing with software problems. Put that in writing. Process matters just as much as terms. Insist on monthly itemized bills. When you receive them, skim for 3 things: clarity, proportionality, and linkage to outcomes. Clarity. Do entries explain the task and purpose? Proportionality. Does the time spent match the importance of the task? Linkage. Can you see how this moved you closer to a decision point, a filing, a negotiation session, or a settlement term? If something is vague, reply promptly. Within 10 days is a good norm, and ask for a narrative. Can you explain what was accomplished in this time block and how it advances our strategy? Keep it calm and specific. You're not disputing effort, you're asking for transparency. Also, set communication rules to reduce waste. For example, use agendas for scheduled calls, batch non-urgent questions into a single email each week, and prefer short memos for major decisions so there's a written record you can revisit. These small habits cut down on back and forth that burns time without adding clarity. Finally, ask at the outset, if we have a fee dispute, how is it handled? Many state bars offer or require fee arbitration or mediation. Knowing that pathway exists promotes fair billing practices and gives you a safety valve if concerns arise. Here's the bottom line. Your fee agreement is a control system. With clear scopes, sensible staffing, transparent billing, and a fair dispute process, you align incentives and keep the case focused on resolution. The goal is not to fight about invoices. It's to ensure every dollar you spend increases leverage, clarifies issues, and moves you toward a durable, fair settlement. ethical advocacy has boundaries. Your lawyer must promptly convey settlement offers and be candid about facts with the court. They can't mislead on evidence. Conflicts of interest, like dating a client, taking money from the other party, or having a financial stake in an outcome, are major red flags. And confidentiality isn't optional. Casual disclosures can violate duties and damage your case. Culturally, be cautious of lawyers who market scorched earth as a default. That energy might feel protective, but it often creates collateral damage. Higher fees, worse co-parenting dynamics, and unpredictable rulings. Zealous doesn't mean reckless. It means focused, ethical, and effective. Your action step. Ask your attorney to put your objectives in writing with constraints, cost ceilings, civility expectations, and a settlement-first bias. If the vibe is destroy first, justify later, pause. You want a strategist, not a flamethrower. High conflict dynamics with kids. When children are involved, pressure tactics can escalate quickly. Alienation claims and emergency motions can be used legitimately, but they can also be misused to force concessions. Over-reliance on custody evaluators can entrench bias, and bills from guardians ad litem can balloon if roles aren't crystal clear. Courts tend to reward parents who foster safe, stable contact and follow orders. Judges notice who is child-centered versus who is using kids as leverage. Your job is to align litigation choices with child outcomes. Stability, routine, and healthy relationships where safe. Action items. Demand clear scopes for any evaluator or guardian ad litem, deliverables, timelines, and cost controls. Document parenting efforts neutrally in a parenting app. Before filing any emergency motion, request a written risk-benefit analysis. What relief is realistic? What will it cost? What are the consequences if it's denied? Keep the focus on your child's well-being, not tactical drama. How to protect yourself as a client. Protection starts before you hire. Interview 2 or 3 attorneys. Ask about settlement rates, typical timelines, and how they measure success. Request a sample invoice and a short written strategy memo tailored to your facts. Check discipline history and verified reviews. Once engaged, put structure around the relationship. Set objectives, budget caps, and communication rules in writing. Use agendas for calls and send short recap emails to memorialize decisions. Insist on monthly itemized bills and question vague entries promptly. Decision hygiene matters. Consider mediation or collaborative law first when appropriate. Ask for BATNA/WATNA, best and worst alternatives, before major moves, and use parenting tools to reduce friction outside the courtroom. Your mantra, clarity beats intensity. The more you translate emotions into specific goals, budgets, and procedures, the less room there is for drift, miscommunication, and unnecessary expense. If you suspect misconduct, if something feels off, escalate calmly and in writing. Start by outlining your concern to your attorney, specific entries, dates, or decisions, and request a billing or strategy conference. Often, clarity fixes misunderstandings. If trust is shaken, get a second opinion. Share your file and latest invoice with another lawyer for a discreet review. If issues persist, switch counsel. You own your file, request it promptly. For fees, many bars offer arbitration or mediation. For serious ethics concerns like dishonesty, conflicts, or confidentiality breaches, consider filing a grievance with your state bar. Keep a contemporaneous log of events, dates, statements, invoices, and outcomes. Documentation is your ally. Time limits can apply to fee disputes and complaints, so check your jurisdiction's rules. The goal isn't retaliation, it's course correction. A measured, documented approach protects your case, your budget, and your credibility with the court. Would you like these adapted into speaker notes formatted for Canva, Google Slides, or PowerPoint? I can also tighten each to a 60-second version if you're targeting a faster pace. Bottom line, let's zoom out and focus on what matters. Most problems in divorce litigation aren't masterminded by villains. They're produced by incentives and emotion colliding with a complex system. When you understand that, you stop taking every aggressive move personally and start treating it as a variable to manage. Measure progress by movement towards settlement, not by the volume of activity. A flurry of emails, motions, and meetings can feel like momentum, but ask, did this reduce issues, clarify facts, or close the gap to agreement? If not, it's noise. Your resources, money, time, energy, are finite. Spend them where they create leverage, focused negotiation, targeted discovery, and child-centered solutions if you have kids. You are the client. That means you set goals and require clarity. Ask for plain language strategy memos, budget forecasts, and decision trees before big moves. Put cost ceilings and communication rules in writing. Helpful starting points. Let's finish with practical resources you can use immediately. First, a settlement-first mindset. Look up family law mediators and collaborative divorce groups in your state. These professionals are built around problem-solving rather than point scoring, and even if mediation doesn't resolve everything, it can narrow disputes and slash costs. Parenting coordination and reputable co-parenting apps can also stabilize day-to-day routines and reduce the fuel for litigation. Second, use your state bar tools. Most state bars have attorney lookup portals where you can confirm licenses and review any public discipline. Many also offer fee arbitration or mediation, which can de-escalate billing disputes without a court fight. Your local court's self-help center is another underrated resource. Forms, timelines, and procedural guides that make you a better consumer of legal services. Third, due diligence with firms. Ask for a sample engagement letter and a sample invoice before you sign.